So if you have an arbitration, and there's a lot of talk about arbitration agreements, and there's a lot going on with that, I would say that you definitely want to make sure that you are speaking with your in-house counsel if you have it, or with an attorney, preferably a labor law attorney, if you are going to have an arbitration agreement in your employee manual. Take a look at that a second time, because there's a lot of things that have come up recently about arbitration agreements, and you're going to want to make sure that you get some really sound and good advice. I believe we may have some arbitration agreement information in our packets, and I want to say, and I'm going to just kind of borrow yours here for a minute, I want to say that this is from our attorney, Seahart and Shaw, and there's some really good information here about arbitration agreements. Yes, ma'am?
What happens when employees refuse to sign?
Well, an employee can refuse to sign anything. It doesn't mean that they are not liable for being held, responsible for complying with those. That's just like anything else. Even with a disciplinary action that's taken or any other type, you just put employer refused to sign, but was given a copy. There you go. All right. So our last case here had to do with the Sheet Metal Workers International Association and Brandon Regional Medical Center. In this case, an acute care hospital engaged in the services of an open shop sheet metal contractor to perform work on an addition to the hospital. Now, the union had a primary dispute with Macy Metals, Inc., okay, an open shop labor supply company. Now, and also the workers' temporary staffing that the contractor had used. The hospital was a neutral secondary employer, okay? The union was seeking to persuade the neutral employer, Brandon Hospital, to cease doing business with Macy and with the WTS by engaging in various protests to publicize the dispute in the vicinity of the hospital. They placed this rack, which was 16 feet high and 12 feet wide, this big inflatable rack balloon with a sign that identified that there was a dispute with the labor supply company, and they identified that labor supply company. They put this on public property, and it was 100 feet away from the hospital's front entrance. The sign declared, "There's a rat at Brandon Hospital." All right, union members also distributed leaflets at the site that identified the labor supply contractor as a rat employer. Among other things, the leaflets actually included a cartoon of a rat in a patient's hospital room with a person standing behind the rat cleaning up its droppings, sweeping up its droppings. It gets better. When the union organizer was asked by the hospital's safety and security director what the union was doing, the organizer replied that the union was picketing, okay, and explained that the rat balloon would possibly get the attention of the public more than if they were just giving out regular handbills. All right, gets better. Now, following the rat display, the union also staged a mock funeral. Can you imagine, in front of a hospital, a mock funeral procession while distributing leaflets which asserted that Brandon Hospital going to Brandon Hospital should not be a grave affair, okay? And described the medical malpractice lawsuits filed against the hospital, all right? So the leaflets did not mention the labor dispute, but instead stated that it was a public service message that the union was providing to the consumer. The majority ruling in a board decision 3-1, okay, 3-1 here, held that the union did not violate any laws by allowing, can you believe that? By allowing them to display because there was sufficient distance and they were sufficient distance from the vehicle and from the entrance of the hospital. Can you believe that? The hospital had nothing to do with it. That's the point of this particular hospital. They were just a third party. The interesting part about this is this was in California. The rat was manufactured by a non-union company outside of Illinois. Very nice. Very nice. Okay, and again, the NLRB found that the picketing was secondary. He found that picketing secondary employers is not allowed, but the handbilling is allowed, and the rat was non-confrontational. Okay, so very interesting case in that. All right, so let's talk about some of the changes. The ADA was revised last year. The rule became effective March 15th. We actually have a 1-hour presentation that talks about ADA, but we're going to go over some of the changes briefly. Title II of the ADA requires non-discrimination on the basis of a disability in governmental services. Title III of the ADA covers private enterprises and facilities and what requirements they must put in place to accommodate those who are disabled, okay? Like ramps, elevators, larger doorways, etc. Examples of private enterprises include financial institutions, hospitals, doctors' offices, that sort of thing, shopping centers, daycare centers, fitness clubs, and such. The main point on this slide is when it comes to the ADA, there's a responsibility on the part of the employee and the employer to have interactive dialogue. I encourage you to write this down. Interactive dialogue. We are engaging in the interactive process. If you do not use those words, you're going to be in big trouble as it relates to the ADA. You have to actually say those words and document those words, the interactive process. Okay? That you are going to try to go through that process to see if you can provide reasonable accommodation. Okay?
Those exact words, no
Those
variation.
exact words, no variation.
One more time again. The
Okay.
interactive process.
The interactive process. I believe there is a handout, if I'm not mistaken, in your packet.
There is.
And Scott,
And should anybody have a packet that I may have missed one from my
Here we go. It looks like this. It says the reasonable accommodation process. What we've given you is a 10-point checklist. This is something that I encourage you, if you have not reviewed your employee handbook in a while, and you have a leave of absence policy, you're going to want to address under your leave of absences, including leave as they relate to workers' compensation as well. So it's both work-related injuries as well as personal illnesses and injuries. Very, very important. All right, so let's go into, let's talk about what's new and effective for January, which I cannot believe we are already at the end of January. So San Francisco, if you live in California, you already know that California in itself is just one of those states that, you know, we set the standards, we're one of the strictest in the country, but we have to take it one step further and have a city within the state of California that decides how they're going to do everything, when they're going to do it, and they really set the standard for the state in itself. I'd like Scott to talk about San Francisco because he's from Northern California, specifically Sacramento, and he understands all the ins and outs of what goes on in the minds of the San Francisco.
I don't know if anybody understands the ins and outs, even if you wrote the rules and the law. City of San Francisco is, as Stacy described it, is kind of a city upon itself. They're usually the first point of change when it comes to labor law in the state of California. Even though none of you probably have employees in San Francisco, but if you do, please take heed of these items. You look at this say, well, okay, I'm not in San Francisco, I don't need to pay attention to this. This is what happens in the rest of the state. This starts in San Francisco and it flows downhill, as other stuff does. City of San Francisco it's a really touchy thing. And one of the things you'll notice is our lieutenant governor is the previous mayor of San Francisco. And many of these laws that we're actually talking about here are ones that he supported and he pushed through. So his agenda is to continue them throughout the state, Mr. Newsom. Mr. Nuisance.